this morning. Well, may I once again welcome all those who have attended the hearing suite in Edinburgh this morning, and also those who are watching and listening to the proceedings remotely, to the inquiry's opening statements hearing. Today marks the next important staging post in the inquiry's progress as we move away from its necessary but preliminary establishment phase. As its description suggests, the principal purpose of this hearing is to provide a forum for core participants through their recognised legal representatives to make opening statements on matters of interest and importance to them, arising from the terms of reference fixed by the Cabinet Secretary for Health and Social Care, and also the inquiry's list of issues, an updated version of which is on the inquiry website, following the informative period of consultation, which followed its original publication and circulation. But the opening statements hearing also serves another very important purpose, and that is to provide an opportunity for the inquiry to provide you all with an update on its work since the preliminary hearing on the 10th of September this year. Senior counsel to the inquiry circulated in advance of today a detailed outline of where matters stand in that respect, and it has been and is open to the representatives of core participants to make submissions on matters arising from that update as well. Pursuant to the agenda prepared for this hearing and also circulated in advance, you may expect to hear submissions this morning from Mr. Dawson and thereafter from counsel representing core participants represented by Levy and McRae, NHS Tayside, the Scottish Ministers, the Royal College of Surgeons of Edinburgh, Healthcare Improvement Scotland, and NHS Education for Scotland. At my invitation, the chair of the Independent Clinical Review, Professor Wigmore, has also caused a submission to be tendered on behalf of that process. And I am grateful to Mr. McGilvray for attending the hearing to speak to that submission at the appropriate time. The holding of a bespoke opening statements hearing reflects the inquiry's previously stated commitment to engage constructively and to communicate with all of those who are interested in its work. I therefore hope that you will find the hearing to be informative and useful. But I also immediately recognise that the issues likely to be covered remain very difficult and challenging for many. Can I therefore reiterate to all those who are in attendance or otherwise interested in the inquiry's work of the importance of interacting with others with courtesy and respect. As I said on the last occasion, but it merits emphasis, it is in such a spirit that the inquiry is likely to obtain the best possible evidence to support its investigations going forward. In terms of today's practical arrangements, it would be my intention to have a mid-morning break in about 1 hour from now, and we will aim to take a 1 hour break for lunch at about 1 o'clock. And so with that brief introduction, I will now invite Mr. Dawson to address the hearing. Mr. Dawson, when you're ready.
Good morning, sir. I am Jamie Dawson, KC, and I appear as Senior Counsel to the inquiry, along with my learned juniors, Ms Alex Price-Marmion and Mr Cameron Smith, advocates at this opening statement hearing of the Eljamel inquiry. This is the second of the inquiry's public hearings, a preliminary hearing having taken place on the 10th of September of this year. As at that hearing, the inquiry team and you, sir, are joined in the inquiry's hearing space for this two-day hearing at Waverley Gate in central Edinburgh by a number of core participants or representatives of core participants or members of the public who are attending in person in the public gallery, by a number of members of the media who are present in the building, watching the proceedings from the media room, by a larger number of core participants or core participant representatives and members of the public and media who are joining us via the live stream, which the inquiry makes available for those who cannot or do not wish to join us in person, but who take an interest in our work, and by legal representatives of our core participants, who will play a more active part in this hearing than they were called upon to do at the preliminary hearing in September, as I will come to explain. All are very welcome. As was the case at our preliminary hearing in September, the video feed on YouTube will be transmitted with a delay of a few minutes. This mechanism is part of the systems we have in place to try to prevent any confidential information being transmitted to the wider public which should not be. Those who have submitted written opening statements have kindly refrained from mentioning individuals in them whom they do not represent, or beyond those whose names they are clear can be published. In such cases, they have provided or will provide the inquiry with the actual names separately. This will assist with our investigations, but respects also the need for individuals not to be named at this public hearing, who have not had the opportunity to apply to ask you, sir, to pronounce a restriction order protecting their identity. I would ask those who are making oral contributions to continue to be vigilant about that in their statements, and to avoid naming individuals on whose behalf they cannot speak, in accordance with those principles and aims. In the event that something is said by me or by another contributor which seems to us to contain information which ought not to have been referred to, I will instruct those who are managing the YouTube transmission to cut the feed. They will stop the transmission, and we will most likely have a short break to work out how we need to proceed. My apologies in advance for any interruption which we may need to make of submissions of others for this purpose. This is why it will be necessary to do so. Any such information which is inadvertently referred to must not be referred to or otherwise shared out with this room, and is subject to the inquiry's first order, covering those in attendance, including members of the media. The plans for this hearing. Sir, the purpose of this hearing is primarily to hear from our core participants via their legal representatives. It is the right of the legal representative of a core participant in the inquiry to make an opening statement under Rule 10 of the Inquiry Scotland Rules 2007, unless the Chair directs otherwise, though the nature and format of them are matters which are within your control, sir. In accordance with our approach to allow active participation by our core participants in our work, core participants were sent some guidance as to the sorts of matters they might wish to cover, and were invited to make written opening statements to the inquiry, as well as oral statements at this hearing. The guidance sought to have the statements focus on more substantive matters, given the largely procedural focus of our preliminary hearing, and the need, at this point in our planning, to start to make progress with our substantive investigations, which our terms of reference demand that we do. In particular, core participants were asked to cover matters in their statements, including the following. Contributions were sought which focused on the substance of the inquiry's work, as opposed to procedural matters, including aspects of the inquiry's terms of reference and list of issues, as updated to October 2025, post-consultation with core participants, of particular importance to a core participant group, or meriting particular or particularly detailed attention on the part of the inquiry, and why. Particular features of neurosurgery undertaken or proposed for Mr. Eljamel's patients, where core participants felt that things could have gone better or lessons could be learned through the inquiry process. The extent to which it is submitted that the inquiry's remit should extend beyond Mr. Eljamel's practice at Ninewells Hospital into other parts of the NHS, for example, other hospitals in which he may have practiced, for example, Dundee Royal Infirmary or within NHS Fife. Other roles which could fall within term of reference 1, relating to appointments beyond those listed there and why, manifestations of the effects of workload pressures on the way in which Mr. Eljamel's patients were treated under term of reference 2C, research projects in which Mr. Eljamel was involved, in which core participants submit that the inquiry should take an interest and why, under term of reference 2E, particular matters which the inquiry ought to investigate relating to the training and supervision of junior neurosurgical staff, under term of reference 2B, the extent to which there is a basis for the inquiry to investigate complaints or concerns raised about Mr. Eljamel's practice prior to 2012, and the nature of any such complaints or concerns, under terms of reference 4 and 5. Submissions about broad issues with candour or lack of it on Mr. Eljamel's part under term of reference 7, which the inquiry should investigate. Particular issues which core participants submitted arise in connection with Mr. Eljamel's clinical supervision under term of reference 8, or suspension under term of reference 9, which merit the inquiry's investigation and consideration. Aspects of the investigations listed under term of reference 12, which core participants felt merited particular attention, with reasonable grounds upon which it is asserted that those investigations could or should have worked better, and information about reports made to bodies mentioned in term of reference 13, and reasonable assertions about what reports could or should have been made to them, when and why. Further, the core participants were asked to provide additional issues or matters of greater detail which core participants consider should be investigated by the inquiry and why, including why they were deemed to fall within the inquiry's terms of reference, suggestions as to the identity of witnesses from whom core participants submitted that the inquiry should be taking written statements and or oral evidence, the role which such individuals were expected to be able to play, and why their involvement in those ways would be beneficial to the inquiry's fulfilment of its terms of reference, with reference to the particular issues or terms of reference to which it is thought that these individuals would be able to contribute where possible. We indicated that you, Chair, would be particularly interested to hear from core participants as to the identity of individuals working within NHS Tayside on the medical side, including surgical, nursing or other staff, whether from the neurosurgical department or beyond, or the administrative side, whom CPs submitted would be of assistance to the inquiry, and why. Suggestions as to lines of investigation which core participants thought should be undertaken by the inquiry and why, beyond those already announced at the inquiry's preliminary hearing. Any key materials which core participant groups held and or thought should be obtained by the inquiry and why, as well as any information about key documents thought to be missing, which might otherwise have been of assistance. Aspects of the inquiry's terms of reference or list of issues, or indeed its sectional evidential plan, to which core participant groups thought they could contribute to the greatest extent, and matters where their contribution would be of the greatest assistance to the inquiry's work and why, and beyond plans already announced at the inquiry's preliminary hearing in the protocol or in the protocols published by the inquiry, matters which core participants considered should be raised with independent expert witnesses, the areas which expert evidence should cover, and the identity of any expert witnesses whom core participants thought would be able to provide technical evidence of assistance to the inquiry's work and why. Broadly, aspects of the inquiry's evidential approach and procedures on which core participants wished to express a view or required further assistance or guidance, for example, processes for anonymity, participation in evidential hearings and the like. Recommendations which core participants submitted should be in the inquiry's thinking at this stage, including the identification of areas connected to the inquiry's terms of reference, which core participants considered would be most likely to benefit from the inquiry's attention and possibly ultimately recommendations being made based on the core participant group's particular experiences or areas of particular interest. And finally, the inquiry's proposed approach to its trauma-informed policy, which in due course will form an important part of its wider engagement strategy, and the extent to which core participants propose to contribute to or participate in it. Within the broad parameters of the guidance they were sent, core participants have been given a relatively free rein to set out their clients' perspectives on, aspirations for, and contributions to the planning work of the inquiry. These statements are important to the inquiry's work. They will be taken into account as part of the inquiry's genuine commitment to allowing its core participants to have a voice and to play a meaningful part in our work. It is that commitment which has motivated the inquiry to hold this hearing in this way and at this time. By holding this hearing now, it is anticipated that the inquiry will still have the opportunity to incorporate the helpful contributions which have been and will be made over the next 2 days into our approach as to how we go about our work. It is for those reasons that the floor will shortly pass to the legal representatives of the core participants in order to allow their clients to take centre stage. However, before doing so, sir, I would like to take the opportunity to set out the broad timetable for this hearing, but also, as part of the inquiry's commitment to openness and clarity, to present an update on the inquiry's work since the preliminary hearing on the 10th of September. Core participants were given information about these developments in a note by Council to the inquiry circulated last week, on which they were asked to provide written submissions by Monday morning. The inquiry team is grateful to all those who took the trouble to do so. Though I will try largely to leave the stage to my colleagues representing their core participant clients for their opening statements, I will try to address aspects of the submissions on the procedural issues raised in Council's note as I go along, for the sake of clarity and the best use of time. The opening statements hearing timetable. The opening statement hearing will be attended by representatives of the following core participants, on whose behalf written and oral opening statements have been or will be submitted or delivered as follows. Firstly, the 138 former patients of Mr. Eljamel and 21 representatives of former patients of Mr. Eljamel, represented by Levy and McRae solicitors as individual core participants. These patient core participants are represented by my learned friends Joanna Cherry KC and Mr. Ewan Scott. They appear on behalf of this group today and have provided you with a written opening statement and a written submission on the CTI note. Ms. Cherry will address you after I have spoken. NHS Tayside are represented by my learned friend Ms. Una Doherty KC and Ms. Kat McQueen. They have provided a written opening statement and a written submission on the CTI note as well. Ms. Doherty will deliver an oral opening statement on their behalf this afternoon. The Scottish Ministers are represented by my learned friends Laura Thompson KC and Mr. David Blair. The current plan is that Ms. Thompson will deliver an oral opening statement on their behalf this afternoon after Ms. Doherty has addressed you, sir. As was the case at the preliminary hearing, my understanding is that my learned friends represent the Scottish Ministers in their capacity as core participants in and material providers to the inquiry, as opposed to representing the Ministers in any other capacity, such as the Cabinet Secretary in his capacity as sponsoring Minister of the Inquiry or the Independent Clinical Review. The Cabinet Secretary for Health and Social Care was invited to be represented in his capacity as sponsoring Minister of the Independent Clinical Review for particular reasons to which I will return. He is, as I understand it, not so represented at this hearing. Healthcare Improvement Scotland have provided a written opening statement and are represented at this hearing by Mr. Shane Dundas. He will make an oral opening statement on their behalf tomorrow morning. NHS Education for Scotland have provided a written opening statement and are also represented at this hearing by Mr. Shane Dundas. He will make an oral statement on their behalf tomorrow morning as well. The Royal College of Surgeons of Edinburgh have provided a written opening statement and are also represented at this hearing by Ms. Christine O'Neill KC. She will make an oral opening statement on their behalf tomorrow morning. Additionally, as happened at the preliminary hearing, you have also invited the Independent Clinical Review to be represented at this hearing, have sent them the same advance materials as were received by core participants, and extended to them the same rights of reply and participation on the procedural matters raised in the CTI note, for the same objective of seeking to allow them to contribute to the efficient work of this hearing and of the inquiry. I will return to the ICR as a separate item on my agenda in due course. The ICR is represented by Mr. Ewan McGilvray of Morton Fraser McRoberts Solicitors. The ICR has provided a written submission, and Mr. McGilvray will address you on behalf of his clients tomorrow on matters raised in the CTI note. The legal representatives of the University of Dundee have submitted a short written opening statement. They are not represented at the hearing. It is of note that in their written opening submission and at paragraph 6 of their written submission on the CTI note, the patient group have raised an issue about the apparent lack of engagement which the University of Dundee have had with this inquiry, and raise again the importance of matters which relate to the University in the inquiry's investigations. They highlight, quite rightly, the importance of the University's engagement with the inquiry, which is the basis upon which you granted them core participant status, sir. In the University's short written statement, they make reference to significant financial constraints, which are a matter of public record, as a contributing factor to this position. The University remains a welcome core participant in the inquiry and requires to make its own decisions about what it wishes to do in that capacity, including participation in this hearing. For the sake of those who have concerns in this regard, may I clarify that their lack of participation in their capacity as core participants should not be confused with their participation in their capacity as organisational witnesses or material providers to the inquiry. The inquiry will be asked to provide evidence by way of written statement, oral evidence as is deemed necessary, and in the form of documents relevant to the inquiry's investigations, in its capacity as a witness or material provider. In those capacities, the University will not ultimately have the option as to whether to participate. It will require to provide evidence which it holds or can provide and which is relevant to our work, by use of the inquiry's powers of compulsion, if necessary. It is hoped that that will not be necessary. The University is currently in receipt of a Rule 8 request for documents and a corporate witness statement relevant to Section 1 of the inquiry's hearings programme, which is currently being worked on, as we understand it. When the opening statements of our core participants who are represented here have been heard, I will address you further, sir, raising any matters which I think it would be worth addressing at this stage in this public forum. As this hearing is predominantly for the core participants to make their statements, I do not plan at this stage to have a lot to say in reply, but will be listening with interest to what is submitted and will reply on any matters which appear to be worthy of further reply or clarification on behalf of the inquiry. It may be, sir, that the timings do not run precisely to the planned agenda. However, based on projections made by my colleagues and the allocation of 2 days rather than 1 for this hearing, we are sure, as one can be, that everyone will be able to contribute what they want to say, and all relevant issues will be amply ventilated. We will, of course, be respectful of the needs of those in attendance for breaks. Therefore, sir, by way of an update on progress and planning, I intend to address you, sir, on the following topics. Firstly, future hearings dates. Secondly, an inquiry staffing update. Thirdly, a core participant update. Fourthly, the inquiry's list of issues. Fifthly, Rule 8 requests and Section 21 notices. Then the independent clinical review, instruction of expert witnesses, and the consultation on the inquiry's trauma-informed approach. Future hearings dates. As far as the planning of future hearings is concerned, and as those who take an interest in our work will be aware, the inquiry has, for reasons of expediency and economy, entered into a venue sharing agreement with the Scottish COVID-19 inquiry, which means that its hearings will be held at the premises at Waverley Gate in Edinburgh, which have been used for the hearings of that public inquiry and where we find ourselves for the opening statement hearing today. The windows available to this inquiry for its hearings in the first half of next year are in February 2026, 3 weeks from the 9th of February, and in the spring, 3 weeks from the 20th of April. The plan, which was announced at the preliminary hearing, was that the evidential hearings in Section 1 of our evidential plan would be held in the February window, and that the first set of evidential hearings in Section 2 would take place in the spring of 2026. Regrettably, the inquiry has experienced a number of issues in its progress so far, with the result that you have taken the decision, sir, that the hearings which were to have been held in February will now not go ahead as planned. There are a number of reasons for this, which I would like to set out, in the spirit of openness and clarity in which we endeavour to undertake all of our work. I will turn to these in a moment, but first of all, may I set out how this development will affect our planning. The hearings in Section 1, which were due to take place in February, will now take place in the 3-week slot available to us in the week commencing the 20th of April 2026. The next hearing room slot available to us will be in the autumn of 2026, at which time we will hold the Section 2 hearings, which, as you know, sir, will focus on the evidence of patients, patient representatives, and evidence emanating from the independent clinical review. In order to try to mitigate the effects of the delay and to seek to try to get the hearings back onto the timetable they were originally designed to follow, the inquiry has reserved a slot running for 4 weeks from the 7th of September 2026 with our colleagues at the Scottish COVID-19 Inquiry. Core participants will, of course, be informed of the precise plans for the hearing of oral evidence over that period. However, it is hoped that this broad plan may allow the inquiry to get back to where it would otherwise have been in its timetabling, with Section 2 taking place in the autumn of 2026, as had previously been announced. The reasons why this change of schedule is taking place are as follows. As I have said previously, sir, the inquiry strives constantly to balance speed and reasonable thoroughness in its investigations. Both considerations are important, and both are integral to our remit, as set out by our terms of reference. Constant vigilance is needed to ensure that that balance is being properly maintained. This is difficult, and sound judgment is required to ensure that we are making decisions in that regard which comply with our terms of reference, our principles, our objectives, and to recognise the fact that some of what we do is dependent on others. In this instance, that judgment has been exercised in a way which will result in a change in our planning, which has been determined to be the best way to balance these factors in exercise of your discretionary right to fix the inquiry's procedures as you see fit, subject to considerations of fairness and economy. First, many core participants have pointed out issues with the independent clinical review process, upon which the inquiry is evidentially reliant as things currently stand. To reiterate, the inquiry is reliant on the ICR's evidential output as A, the basis for understanding what went broadly clinically wrong, and as the foundation for our broadly systemic investigation, and B, as the source of direct evidence of patients and patient representatives in the form of their applicant statements. Both Ms. Cherry and I raised concerns about the progress of the ICR project at the preliminary hearing in September. The situation, as far as the inquiry was concerned, was urgent at that time. Progress, you will recall, was demanded. I will return to the progress made in that regard to this point in due course, but the time the inquiry team has spent on ICR-related matters and issues standing in the way of progress beyond the inquiry's control are matters of lingering concern, which have impacted on the change of timetabling. Secondly, and related to this, the inquiry team has taken time to consider the implications of these delays on the applicants to the ICR, patients, and in some cases their representatives. They will, the inquiry hopes in early course, be called upon to produce applicant statements to the ICR. It is reasonably anticipated that that will be a difficult process for many, and one which will need to be prioritised in the joint planning of the two processes. The applicant statements will be needed for the ICR neurosurgical reviews to be completed. Equally, the inquiry will need them to see and take account of their content in its work. Though the inquiry already has an eye to the identity of patients or patient representatives from whom it will, in due course, seek its own inquiry statements, the procedures which have been developed between the two processes have been designed to try to minimise what will inevitably be a heavy burden on those who are involved. Thus, the prospect of being able to complete both applicant statements and, in some cases, inquiry statements by the scheduled April hearings window for the first tranche of the Section 2 hearings has appeared increasingly unrealistic and, most importantly, unfair. Such unfairness requires to be avoided. The importance of that body of evidence to both the patient witnesses and to the inquiry is amply set out in the written opening statement of the patient group. It is hoped that the adjustment to the timetable will assist in according that evidence the attention and importance it clearly merits in what you, sir, have designed as an inquiry with the patients at its centre. Thirdly, in the course of the preparation of the Section 1 evidence, which the inquiry has now sought, and to which I will return, the inquiry has received some intimation of issues with meeting deadlines with Rule 8 requests which have been sent out. Some recipients have raised issues arising from the time of year. Some organisations in receipt of Rule 8 requests have been asked to provide updates on their progress, as they were required to do, by the 20th of November. These progress reports have given rise to further issues and requests for extensions, which the inquiry considers to be not wholly unreasonable in the circumstances. Those in receipt of such requests deserve to be treated fairly too. These issues, therefore, are required to be factored into the inquiry's planning in order to make the hearings as productive and inclusive as possible. It is clear that more time should allow those who have been asked to contribute evidence the time to provide more meaningful contributions, as well as permitting the necessary processing of statements and documents and their onward disclosure to our core participants. Those who have requested that deadlines be extended will have their applications assessed after these hearings. Core participants will be updated about the plans for disclosure as soon as there is any update to provide. Those involved should, however, not expect lengthy extensions, and work should continue at pace, given that delay in the hearings from February to April is only in the order of around 10 weeks. Fourthly, as you are well aware, sir, the inquiry has in place systems to allow core participants to participate in key aspects of its work in its preliminary phase. These opportunities are important to the inquiry's principles of clarity, openness and collaboration. Though core participants were asked to contribute to the text of standard form letters of instruction for the ICR experts, the inquiry has not yet had the opportunity to engage core participants in the instruction of its own expert witnesses. As this expert evidence forms an important part of the evidential context in which the inquiry's work will be undertaken, the inquiry wishes to allow core participants a reasonable opportunity to make such a contribution, which could not reasonably have been expected of them before now. As this evidence is scheduled to be part of the inquiry's evidential Section 1, the delay in the Section 1 hearings until April should, we hope, allow the established process of participation to take place as planned. Fifthly, the inquiry requires to engage the services of key members of its own team, whose role will directly relate to the hearings, namely a hearings and operations manager and a witness liaison officer. I will return to the issue of inquiry staffing in a moment, but without these key members of our team, the hearings in February simply could not function adequately for our purposes and in accordance with the needs of those who would be attending to provide evidence. Sixthly, the inquiry's trauma-informed policy public consultation has just recently got underway. Given the importance of the contributions which we hope will be made to this policy in that process, and in turn to our engagement strategy as a whole, the postponement of the hearings will allow greater account to be taken of these highly important considerations in our work at the first set of evidential hearings. In the meantime, core participants are reminded that the public hearings of the inquiry will be live streamed. Transcripts of evidential hearings will be published on the inquiry's website. Information about the conduct of those evidential hearings and the broad outline of the process which will be followed in advance of it and at it is as set out in the inquiry's public hearings protocol. I should point out, sir, that it is entirely possible that you may wish to order further preliminary hearing be held before the Section 1 hearings, which are scheduled for the week commencing the 20th of April 2026. You may do so, sir, if you consider that there are matters which require public ventilation and resolution, including, but not limited to, any issues which you have with the recovery of evidence relating to those Section 1 hearings, or expected progress with the work of the ICR, which will have a direct bearing on our Section 2 hearings, now scheduled for September 2026, and our preparation for further hearings beyond that. Core participants will be informed of any plans for a further preliminary hearing. Inquiry staffing update. Since the preliminary hearing, the inquiry has had the benefit of being able to add a number of key members to the inquiry team. For the information of core participants, the following senior roles have now been filled by the following individuals. The important role of Secretary to the Inquiry has been filled by Ms Natalie Smith. Ms Smith already has significant experience from her long career in the UK civil service, including as Deputy Secretary of the Lampard Inquiry, an ongoing public inquiry set up by the UK government into the deaths of mental health patients in Essex. In that role, she was involved in many aspects of the inquiry's work, which will be of considerable relevance and assistance to the work of this inquiry, including financial and project management, development of strategic policy on governance, and coordinating engagement with the inquiry's stakeholders. She is a most welcome addition to the team. The inquiry's former interim secretary, Mr Dan Farthing, has taken the role of Deputy Secretary. In this role, amongst other important responsibilities, Mr Farthing will continue to take the lead in the inquiry's engagement strategy and trauma-informed policy, based on his extensive experience in the charitable sector. The current developments in this area are ones to which I will return. The legal team has also benefited from the appointment of another junior counsel, Mr Cameron Smith, and two assistant solicitors, Ms Claire Sherard and Ms Jennifer Barr, whose work, for now, will focus on the preparations of sections 1 and 2 of the evidential hearings, to which I've already referred. These colleagues are also most welcome additions to the team, with considerable previous experience in the work of public inquiries and/or in the medical sphere in which this inquiry will operate. The inquiry continues to engage in active recruitment processes for a number of other positions in its team, including the important positions of Hearings and Operations Manager and Witness Liaison Officer, to which I've already referred. Those who take an interest in the work of the inquiry should be aware that the processes of recruitment to these key positions is heavily dependent on the recruitment processes operated by the Scottish Government. I have already made clear that the inquiry requires to balance speed and reasonable thoroughness in its work. The latter requires experienced and dedicated individuals to be recruited to our team in order to seek to address the former. The inquiry sought to negotiate it with the Scottish Government, its Scottish Government sponsors, a management agreement which sought to provide for priority to be given to the inquiry's recruitment and other requirements, in particular for speed and control in engaging the right people. This agreement remains unsigned by Government for reasons unconnected to the provision relating to recruitment. The provisions and expectations of the inquiry related to recruitment were and are, as we understand it, uncontroversial. The inquiry continues to consider that the agreement's provisions relating to the priority required in recruitment decisions and processes are entirely reasonable, given the importance of the inquiry's work in the public interest, the requirement that it report as soon as reasonably practicable under Term of Reference 19, and the delays beyond the inquiry's control, which have been encountered to this point. It is a fact that the Scottish Government's recruitment processes have not worked as the inquiry would have expected, in particular as regards the speed with which they operate. Core participants should, however, be aware that processes are well underway for the recruitment of further staff to important inquiry positions, as the inquiry moves from its preliminary to its evidential phase. Those within Scottish Government should, in my submission, take note of A, the reasonable requests of our core participants for the inquiry to be enabled to get on with its work, B, the inquiry's right and need to remain independent, including in the selection and engagement of its staff, and C, the plans for the inquiry's hearings timetable, which I have set out today. I sincerely hope that these requests, that requirement, and those plans will be borne in mind when Scottish Government assistance is sought with ongoing and future recruitment, and that adequate priority will be given to providing it. Core participant update. On the 25th of September 2025, in response to an application received from Levia McRae, USER granted the core participant status to a further 5 former patients of Mr Eljamel and 2 representatives of former patients represented by that firm. This takes the total number of patient and patient representative core participants in that group to a total of 159, comprising 138 former patients and 21 former patient representatives. The Inquiries Rules 2007 enable a chair to grant core participant status at any time during the lifetime of an inquiry. Therefore, USER will continue to consider applications from individuals or bodies who wish to be designated as core participants beyond the initial application period set out in the inquiry's core participant protocol. However, you, sir, are mindful of the need for core participants to be able to participate fully and equally in the inquiry's work. As the current group of individuals and organisations who or which have been granted core participant status already represent a wide range of interests and matters to be covered by the inquiry, and B, as I have said, key stages in the inquiry's plans for active participation have now passed or will pass soon, as the inquiry's preliminary phase nears its end. You have indicated, sir, that you may be less minded to grant further core participant status to future applicants and will indeed require an explanation of the timing of any future application from such individuals or bodies. Core participants who wish to receive funding for their legal representation to support their participation in the inquiry should be aware that the solicitor to the inquiry will imminently issue a further invitation for funding to be granted by the inquiry to cover funding for the inquiry's evidential phase, or at least the first part of it. As it is anticipated that requests for written statements will be part of the next phase of the inquiry's work, the invitation will cover applications for legal representation for the provision of such witness statements, as well as legal representation involved in being a core participant in the inquiry. At the preliminary hearing on the 10th of September, an issue was ventilated relating to the support being offered by NHS Tayside to its current and former employees. NHS Tayside had set out its position in that regard in a written submission to the inquiry. As far as the inquiry was concerned, the position remained unclear. Various issues were raised by me at that hearing, in particular the apparent lack of legal support being offered to current or former employees of the board and the question of their representation. As was the inquiry's stated intention at that hearing, the inquiry has followed this matter up with the NHS Tayside's representatives. They have clarified and updated NHS Tayside's position in a written submission, which was sent to core participants along with a note by Council, both of which will be published after these hearings. The inquiry is grateful to the representatives of NHS Tayside for their clarification of their position in this regard. Given that NHS Tayside indicated in their written note that they have or had concern that their arrangements may cause concerns within the patient body, other core participants were invited to make submissions, if they wish to do so, on NHS Tayside's proposed arrangements for providing legal support, in light of observations in this regard made in the Council to the Inquiry note. The inquiry is obliged to the patient group for having done so. It remains open to representatives of core participant to take these matters up further in their oral opening statements if they wish, in light of NHS Tayside's wish to understand the perspective of others on the arrangements which they propose. The NHS Tayside note clarifies that their position is that they will offer legal support as well as pastoral and administrative support to current and former employees who wish to avail themselves of that support or any part of it. The proposed arrangements are broadly acceptable to the inquiry, subject to certain administrative matters which may still require to be raised by the inquiry with the representatives of NHS Tayside, relating in particular to the practicalities of assistance which they may be able to offer in tracing individuals from whom the inquiry wishes to take evidence. The inquiry will signpost the available legal support services to those former or current employees of NHS Tayside who receive a Rule 8 request or a Section 21 notice for a written statement or for documents to be provided. This will include the broad nature of the support services being offered by the NHS's Central Legal Office and the possibility that individuals may wish to consider seeking alternative representation, as is included in all requests sent to individual Rule 8 recipients. In the case of medical professionals, for example, this may include legal representation by a medical defence organisation or the Nursing and Midwifery Council. Solicitors regularly instructed by medical defence organisations have been in touch with the inquiry to state that they expect to receive such instructions in some cases and that in those cases they will provide legal representation in the normal way. The written note provided by the legal representatives of NHS Tayside makes it clear that they do not represent former or current employees of the board. As they were invited to do in their more recent submission, NHS Tayside have clarified that the inquiry was correct in its assumption that NHS Tayside's recognised legal representatives do not consider themselves to be the recognised legal representatives in terms of the Inquiry Scotland rules of any individual. They are the recognised legal representatives of the board and the board alone. That status brings with it certain rights and responsibilities under the legislation governing the inquiry, the associated rules, and in the inquiry's procedures. No provision is made in any of those for a party providing legal support in connection with the inquiry's work. It was pointed out in the note by counsel to the inquiry that it would require care on the part of NHS Tayside and its employees to ensure that their role as legal supporters should not be confused with their role as recognised legal representatives of the board. It was pointed out that steps would require to be taken to ensure that appropriate systems are in place to facilitate reasonable legal support, a concept of the board's making, as this capacity is one which appears to the inquiry to be one which is not contemplated by the rules. It was observed that this would require to be addressed by the inquiry in certain respects in due course, including in relation to the permissions allowing access on the part of legal advisers to material when they are not recognised legal representatives of the individual witnesses. It has been made clear in NHS Tayside's note that the arrangements would include an assessment being made by NHS Tayside as to whether the legal support service being offered could be extended to an individual based on whether there appeared to be a conflict of interest between the position of that individual and the position of the board. Given the relatively unusual nature of the legal support being offered, viewed in terms of the rules governing the inquiry and those governing legal professionals more generally, as well as the need for as much clarity as can be achieved at this stage, the recognised legal representatives of NHS Tayside were asked to provide clarification as to how it will be ensured that there is an appropriate separation between the advice or support being provided to individuals and the advice or support being provided to the board, in particular in light of the apparent acceptance on the part of the board that, quote, it would not be necessary or desirable for NHS Tayside itself to have sight of a Rule 8 request or Section 21 notice sent to an individual current or former employee, or indeed their response to that request. The board has now helpfully clarified that the legal advice being offered to individual, former or current employees will be provided by a senior solicitor within NHS's central legal office, separate from the team which will be advising the board. It remains unclear whether this means that this senior solicitor will now be the recognised legal representative for these individuals in cases where the central legal office feels able to offer legal support. This is because it remains unclear whether that senior solicitor from the Central Legal Office acts on behalf of the board or not. The separation appears to be intended to promote an appropriate degree of distance between the representation of the board and the legal support offered to former or current employees. That would tend to suggest that the apparent impediment to providing representation for the board and for these individuals is removed by this system, which in turn would tend to suggest that there is no impediment in principle to representation being provided by that separate senior solicitor. On the other hand, the submission still proceeds on the basis that all that would be provided would be legal support as opposed to representation, however legal support is defined. It would be useful if all of this could be clarified, as I say, if the senior solicitor is not a legal representative of the individuals concerned, that will require certain provisions to be made by the inquiry to recognise the more limited status of the legal support being offered. No doubt consideration will be given as to whether it would be appropriate for counsel to be instructed on behalf of those individuals, for example, in connection of those individuals being called to give oral evidence to the inquiry at its hearings, in particular in Section 5 of its evidential plan. I assume that this remains a logical possibility, as under the previous proposal, as I understood it, legal support included the support of the whole legal team, including counsel. Again, clarification of the extent of legal support and the possible involvement of counsel would be helpful. However, subject to these considerations and the inevitable administrative consequences which will need to be ironed out, in general terms, this broad separation seems to the inquiry an appropriate way to balance the requirement for legal support with the need for there to be clarity about the role of the board in evidence provided by individual, current or former employees. The inquiry is grateful to the legal representatives of the board for giving this matter their attention, We will listen to any further submissions made by any party in this regard about any lingering details or concerns with interest. The inquiry's list of issues. During the public consultation on the terms of reference, a number of helpful suggestions were made by participants in that process as to matters which should be included in the inquiry's remit, but which were deemed to be too detailed or specific for the terms of reference. A considerable number of these were incorporated into the inquiry's provisional list of issues, dated June 2025, which is and will remain a living document setting out in greater detail the matters which the inquiry intends to investigate and ultimately to determine. As was set out at the last hearing, the inquiry deliberately devised a number of steps to allow core participants to contribute meaningfully to the inquiry's important preliminary formative phase, building on the inquiry's public consultation on its terms of reference, which took place last year. Opportunities afforded to core participants included or will include the holding of the preliminary hearing in September, including the opportunity to make written and oral submissions, the opportunity to comment on the inquiry's detailed provisional list of issues, to which I will return, the opportunity to contribute to the wording of the standard form letter of instruction to be used to instruct experts in the ICR, the holding of this separate opening statement hearing, including the opportunity to make written and oral statements and written submissions on the CTI note, in due course, the opportunity to make contributions to the letters of instruction to be issued to the inquiry's experts within Section 1 of its evidential plan. These opportunities have been supplemented by the availability of the inquiry team to deal with issues as they arise and to offer explanation and solutions as necessary. It is hoped and expected that this period has been used constructively by those instructed on behalf of core participants, both to prepare themselves to undertake the busy work of the inquiry's impending evidential phases, but also to take detailed instructions from their clients about their aspirations for the work of the inquiry and its investigations. Since the preliminary hearing, the inquiry has received helpful suggestions from core participants relating to matters which, in their view, should be covered in the list of issues. The inquiry is grateful for these contributions. These have been considered carefully by the inquiry team, and additional issues have been included in an updated version of the list to October 2025, available on the inquiry's website. The additional areas included Amongst the additional areas included are the following: policies, regulations, systems, guidance or mechanisms which existed relating to clinicians working within NHS Tayside, insofar as relevant to the care of former NHS patients of Mr Eljamel, regarding the completeness and accuracy of medical records, whether imposed by NHS Tayside or other agencies, and the systems involved in ensuring compliance with them, under term of reference 14. Medical records being sufficiently legible, intelligible or detailed for their purposes, medical records being completed by junior staff as opposed to senior staff, including consultants, medical records not being completed contemporaneously to the events they describe, medical records being altered retrospectively, falsification of medical records insufficiently or inaccurately recording patient consent to treatment, assessment of Mr Eljamel's technical capabilities in surgery at the time of his key appointments in NHS Tayside under term of reference 1, the organisation of the neurosurgical service offered within NHS Tayside and the role of its possible restructuring or withdrawal in the handling of issues with Mr Eljamel, Mr Eljamel's use of products or devices in surgery, in particular where they were unlicensed or used experimentally, issues with multidisciplinary meetings or pre-operative clinics in Mr Eljamel's practice, term of reference 3, formal information sharing arrangements between NHS Tayside and Fernbray Hospital, term of reference 3, the involvement of NHS Tayside in the maintenance of Mr Eljamel's practising privileges at Fernbray Hospital, under term of reference 3, the role of Mr Eljamel's position at the University of Dundee in training in the lack of compliance by junior staff in NHS Tayside whistleblowing or other clinical governance processes, term of reference 3, the differing interpretations and implementation of clinical governance, corporate governance and professional governance within NHS Tayside, term of reference 3, Mr Eljamel's external and internal training requirements of compliance, reporting of issues to the Health and Safety Executive, both of which also fall under term of reference 3, systems for issues about Mr Eljamel being brought to the attention of bodies listed under Term of Reference 6, and the extent to which the outcome of previous reviews related to Mr Eljamel or systems surrounding his practice was reported to the Scottish Government under Term of Reference 12. The inquiry believes that the provisional list of issues published in June 2025, as now updated, provides a proper framework in which to include all of the issues and matters that the inquiry is likely to inquire into, and a sufficient indication for persons and organisations who have relevant information as evidence, as well as core participants, to be able to commence their preparations for the work of the inquiry's evidential phase and their involvement with it. It is anticipated that that will now have happened, and that core participants and their representatives will be ready to progress with the work required of them in the inquiry and in the independent clinical review for those to whom that work applies. The list of issues to be addressed, and indeed those to be addressed in each of the inquiry's evidential sections, however, will be further developed once the responses to Rule 8 requests for evidence have been received. Sir, I intend now to move on to providing some information about our progress with Rule 8 requests and Section 21 notices. That's 11 o'clock when we're due to take a break. I'm in your hands as to whether you'd like to do that now.
Or we might just take, is it a very significant section, Mr Dawson?
Yes, I still have a number of aspects of my submission to cover, so I would suggest that we do so.
Take a break now. All right, everyone, thank you very much. We'll take a break for 15 minutes and resume again after that. Thank you. Thank you. Please be seated.
Thank you, sir. Before the break, I'd reached part 5 of my submission updating people as to the progress that the inquiry has made. This section relates to Rule 8 requests and Section 21 notices issued by the inquiry. Section 1 of the inquiry's investigations is primarily concerned with setting the scene for the rest of the evidence to be heard by the inquiry. It will be an introductory section at which it is intended that evidence will be heard relating to a number of areas which are designed to provide evidential context to the hearing sections to follow, including general background, structure and roles of the various key organisations, key people and key policies, in particular, as well as the systems for complaints and areas in which complaints were made and when. Evidence relating to Term of Reference 1, appointments, including evidence about the broad trajectory of the career of Mr Eljamel and statistical evidence about the nature and spread of his work. Evidence relating to the systems underpinning Term of Reference 14, relating to document management systems within NHS Tayside. The broad ambit and findings of the investigations to be looked at under Term of Reference 12, and independent expert evidence on rules and systems relating to key areas covered by the inquiry's terms of reference, to which I will return. A fuller provisional scope for Section 1 of the hearings has been released to core participants and published. It should be emphasised that as Section 1 of the evidence is intended to provide important factual context to the sections which follow, it will not be necessary for all issues to be ventilated with witnesses who are called to give evidence in Section 1. It is intended that a fuller exploration of the detailed issues of controversy which arise from the analysis of the full range of evidence available to the inquiry will be undertaken at later sections in the inquiry's plan. The inquiry will be willing to consider having witnesses return to provide oral evidence again at an appropriate later stage in its hearings in line with this approach. Rule 8 requests for corporate written statements and the production of documents relevant to the scope of Section 1 of the inquiry's evidential plan have now been completed and issued. These have included reference to matters relevant to the Section 1 scope, which arose from the consultation with core participants on the inquiry's list of issues to which I have referred. Though these sections are introductory in nature, the length of time covered by the inquiry's remit and the broad ambit of matters which you, sir, will require to resolve mean that these are detailed, as even the limited number of matters covered by Section 1 demands a detailed context to be examined. The recipients of these Section 1 Rule 8 requests are NHS Tayside, the Scottish Ministers, the University of Dundee, Healthcare Improvement Scotland, NHS Education Scotland, the Royal College of Surgeons, the Royal College of Surgeons of Edinburgh, NHS Lothian, the General Medical Council, the British Medical Association, the Health and Safety Executive, Circle Healthcare, Police Scotland, the BBC, and 3 members of the Scottish Parliament who have had a prominent role in relation to campaigning for this inquiry. In addition, a general disclosure Rule 8 request has been prepared for NHS Tayside, as well as for others whose Section 1 Rule 8 requests do not cover all documents they hold relating to the inquiry's terms of reference. These will be issued to the relevant recipients in due course when the precise role of these bodies in matters to be investigated by the inquiry becomes clearer. In the meantime, the focus will be on the completion of responses to the Section 1 Rule 8 requests. Section 2 of the inquiry's investigations will focus on the evidence of patients and the evidence which has emerged from the independent clinical review of the timing, nature and extent of clinical issues arising from Mr Eljamel's practice. In Section 2, the inquiry will hear evidence from a selection of patients, and if necessary their representatives, relating to the key clinical themes of substandard practice experienced by patients, including factors listed in Term of Reference 2, and those with experience of matters listed in Terms of Reference 8 to 11. Key aspects of the Terms of Reference relating to the patient experience of relevant systems, including but not limited to complaints and feedback processes, campaigning for a public inquiry and the experience of other investigations listed under Term of Reference 12, lack of candour, Terms of Reference 7 and 13, and issues with document management and access under Term of Reference 14. In Section 2 of the hearings, the inquiry will also hear evidence from the independent clinical review about its findings of substandard clinical practice on the part of Mr Eljamel or those working under his supervision from that process. It is important to note the inquiry intends to call oral evidence in its Section 2 hearings from those who fall into two broad categories. First, those patients whose cases are exemplary of the key broad clinical themes emerging from the ICR. This will allow the inquiry to explore the kinds of things which that process has found went wrong from a patient perspective, which systems that were put in place to protect patients perhaps ought to have done something to address. It is anticipated that that sort of evidence will emerge from the cases which start to be reviewed within the ICR, in particular the priority cases to which I will return. Second, there will be cases which have more of a bearing on the broad position as regards the systems which the inquiry is predominantly charged with investigating from the patient perspective. For example, witnesses may have important evidence to bring to bear on the clinical supervision which was imposed on Mr. Eljamel under Term of Reference 8, or the adequacy of complaints or feedback systems or their follow-up under Terms of Reference 4 or 5, the process of previous investigations, including campaigning for a public inquiry under Term of Reference 12, or indeed other aspects of our Terms of Reference. It is intended that witnesses who appear to have important evidence to provide of their experiences in this regard will be called upon to provide witness statements in the inquiry in accordance with the inquiry's protocol on that subject. Of course, there will be patients who fall into both categories, whose evidence will be derived from both the ICR applicant's statements and ultimate review, and written evidence gathered by the inquiry itself. Medical records and complaints files. In order to inform this process of seeking appropriate evidence, and in light of the delays in the ICR commencing its work, the inquiry has not been idle in recent months. It has already gone about starting to recover medical records and NHS Tayside complaints files using its powers of statutory recovery under the 2005 Act under Section 21, relating to certain former patients of Mr. Eljamel whose cases appear to the inquiry to be of particular significance to its remit, and in anticipation of cases which it will refer to the ICR for review or otherwise assist within the ICR process. So far, the inquiry has recovered all complaints files held by NHS Tayside, medical records from NHS Tayside from Circle Healthcare or from general practitioners. Records of 125 patients have been recovered falling into at least one of these categories. The inquiry will continue to recover records for applicants to the ICR following the procedures agreed in the Memorandum of Understanding between the two processes. The inquiry has informed the patients who are core participants and whose medical records have been recovered by way of patient notification letters. The inquiry will continue to issue these patient notification letters as it recovers records going forward. However, beyond the requirement that these materials be recovered for the ICR reviews, the inquiry has begun analysing these materials for the following purposes. Firstly, informing the creation of a list of priority cases for the ICR, to which I will return. The hospital records for all 50 of these cases have been recovered, as well as the GP records for almost all of them. The remainder will be sought when information about current GP details can be shared with the inquiry by the ICR. Along with information about the cases provided by Messrs Levy and McRae on behalf of their clients, complaint files and publicly available information about the cases. This has allowed a clinical list of 50 priority cases to be compiled, which it is hoped will provide key evidence of the sort of broad patterns of things which may have gone wrong clinically to inform the inquiry's further investigations. Secondly, this process has involved extracting evidence relevant to the compilation of the inquiry's list of issues and compiling a provisional list of witnesses who may give evidence on systemic matters of relevance to the inquiry's terms of reference and who may in due course be sent Rule 8 requests for inquiry witness statements, from which group certain patients or patient representatives will be called to give oral evidence in the Section 2 hearings. And finally, this process has informed further lines of inquiry, including the drafting of questions to be addressed to later witnesses in Rule 8's or Section 21 notices. Publicly circulated materials, including the CTI note issued in connection with the inquiry's preliminary hearing, set out the provisions of the inquiry's general restriction order on the restrictions on publication of medical records generally and the inquiry's processes related to its approach to anonymity and restriction orders relating to extracts from medical records which may require to be published. It should also be noted that the inquiry approach to the recovery, disclosure and publication of medical records is set out in detail in its protocol on the approach to evidence and witness statements from paragraph 57, which involves the minimum amount of medical evidence necessary being disclosed and published for the purposes of our work and that of the ICR. The independent clinical review. In terms of the inquiry's term of reference 16, the inquiry is obliged to take account of the ICR's finding in its work. As I have said, the intention is that the ICR will set out what went wrong clinically. The inquiry's role will then be to investigate what systems should have existed to detect and prevent those things going wrong and harm occurring, and whether those systems were in any way defective. Given this important relationship between the two processes, an invitation has once again been extended by you, sir, to the chair of the ICR in connection with this opening statement hearing. The ICR has not been invited to make an opening statement, but it has been offered the opportunity to make written submissions on procedural matters and to make an oral statement on them. The ICR has provided a written submission, and an oral submission on its behalf will be delivered tomorrow. The ICR was given a copy of the note by counsel to the inquiry at the same time as core participants. It was given access to the opening statements submitted by core participants when these were shared. Relevant matters raised by core participants in their written submissions on procedural matters have been or will be shared with the ICR by the inquiry to enable concerns and suggestions to be addressed appropriately, as was the approach at the preliminary hearing. The two processes have continued to work together to achieve their mutual aims in the period since the preliminary hearing. The following is an indication of the progress that has been made. The inquiry and the ICR have finalised the applicant's statement requests, which will be used in the ICR to allow applicants to input their experiences to the neurosurgical reviews in their case. The applicant's statement request contains a number of questions for applicants relevant to matters which will be the subject of those neurosurgical reviews. There are two versions of the applicant's statement request. These contain the same questions but have different text and parts as they apply respectively to cases in which the applicant consents to materials being shared with the inquiry, known as consent cases, and cases where they do not, non-consent cases. As it is possible in cases where no such consent has been provided that the inquiry will ultimately use its statutory powers to recover the ICR's materials anyway, it is important that the same procedure is followed for the production of applicant statements in all cases. The inquiry has agreed the standard form letter of instruction with the ICR, which will be sent to the independent expert neurosurgeons, in particular to ensure that the questions which they are asked will cover the range of matters on which the inquiry requires the ICR's clinical evidence. Again, there are two versions covering consent and non-consent cases. The questions are the same in each. In cases of particular complexity, which may involve the need to instruct more than one expert, the processes have agreed that the ICR will seek assistance from the inquiry in framing an appropriate letter of instruction. The completion of the draft letters of instruction benefited from suggestions made by inquiry core participants as to matters which should be included in them. A shared operational guide has now been agreed as between the two processes. This sets out the various stages which will be followed in what is a complex operation to process the cases which are being reviewed by the ICR, along with mechanisms for tracking progress to ensure that case reviews are finalised in an orderly fashion. The two processes have required to have particular regard to the complexities and sensitivities relating to data protection, in light of the nature of the medical information which will pass between them. This has required a number of matters to be addressed and appropriate systems designed. The two processes have now agreed the terms of a data sharing agreement between them, which, as far as the inquiry is concerned, will allow information to be shared between the two processes in early course about ICR registrations and the inquiry's nominated priority cases. It will also allow the regular flow of data between the two processes, which has been planned to commence, to enable each process to keep the other aware of the progress it has made and to allow plans to be made and updated accordingly. The two processes still need to finalise the terms of a data protection impact assessment, but this too is nearly in final form. Priority cases. The two processes have agreed systems whereby the cases which appear to the inquiry to be of greatest systemic significance, priority cases, will be processed to review first. As was announced at the preliminary hearing in September, the inquiry has created a list of priority cases which it will ask the ICR to process first, so that the evidential material created by the ICR for applicants and for the inquiry can be processed by the inquiry as early as possible, to allow progress to be achieved as per the inquiry's ambitious timetable. The signature of the data sharing agreement and the imminent completion of the DPIA will permit the details of those 50 priority cases to be shared. Those who represent applicants who fall into this top 50 list will also be informed as soon as that has happened. If it transpires that any of those in the top 50 list have not registered as applicants to the ICR, they will be sent an invitation to do so. If they do not, those cases will proceed as referral cases as per the terms of the Memorandum of Understanding. The inquiry has commenced the compilation of the next batch of cases which it will ask the ICR to prioritise. This will be shared with the ICR and representatives of those whose cases fall into that category at an appropriate juncture. Those who represent the patient core participants will not be asked to contribute to the top 50 cases, a point they raise at paragraph 9 of their submission. They could hardly have been, because as we understand it, they were not formally instructed in the ICR on behalf of those clients until recently, pending completion of funding arrangements being put in place for them to accept those instructions, a point to which I will return. In any case, we have not yet been able to share the list even with the ICR due to data protection restrictions, an impediment which will soon be resolved. To do so at this stage would cause inevitable unnecessary delay. The priority list must be selected by the inquiry as part of its planning and ability to have access to materials from all patients. The Levy-McRae opening statement rightly recognises that though its client group represents a significant cohort of Eljamel patients, it does not represent them all. It would be difficult, if not invidious, for the recognised legal representatives of the Levy-McRae group to be asked to rank their clients' cases, given that they owe the same duty to each of them. That responsibility must fall, and had to fall, to the inquiry team. In any event, as a matter of fact, the compilation of the top 50 cases has had regard to materials provided to the inquiry by Levy and McRae and their counsel, and publicly available materials relating to some of their clients. Thus, submissions about their clients' experiences have already featured in the top 50 assessment. It must also be stressed that, in the allocation of priority cases, the inquiry will retain a role in all cases which progress through the ICR. All of the ICR evidence will become evidence in the inquiry, which will be considered by the Chair in the compilation of his report. Thus, to talk about cases as priority ones is simply an administrative assessment and not one which makes any premature assumptions about the value of any case to the inquiry's work. All cases are important to the ICR and to the inquiry, as they will all contribute to the evidence base of what went wrong and what might reasonably have been done to prevent it. What might be helpful at this stage is to provide some greater clarity about the process which the inquiry has used to compile this list of priority cases. The process has been dictated, to an extent, by the materials to which the inquiry currently has access, which have been recovered as a means of providing a way to make this judgment. In its assessment of those materials, the inquiry has created the following triage process to arrive at the top 50. As the top 50 cases are about the clinical assessment which the ICR will offer, priority is given to those cases which appear on the face of them to offer the most apparently clinically controversial decisions which merit early further investigation based on the information available to us. Those which appear on the face of them to be potentially egregious examples of alleged substandard clinical performance, as defined by reference to matters the ICR experts will be asked to review, for example, lack of consent, incorrectly performed surgery, or surgery not performed at all by way of example, reflective of wider alleged experiences, rank higher in the analysis. Cases which involve surgery or treatment earlier in the period of Mr. Eljamel's employment at NHS Tayside are generally given priority. This is based on the principle that if something was going wrong earlier, something could have been done earlier with a maximum protective effect, and the fact that other previous investigations, hampered by lack of records, appear to us to have paid little regard to cases the more historic they were. The inquiry thus has an important role in looking back as far as its terms of reference require that it does. As the inquiry primarily concerns systems in the NHS, priority is given to those cases which relate to those which come from the NHS, though as private cases also require to be looked at under Term of Reference 3, not all of the cases for priority clinical review come from NHS patients. When things go wrong, people tend to complain. There is a reasonable amount of evidence available to us from the due diligence review of 2023 and the complaints files about complaints, and cases where complaints have been made and upheld are given greater priority than those which have been partially upheld, and so on. As the inquiry will require to investigate the adequacy of complaint systems, we make no assumptions about the correctness of the outcomes of these processes, but this approach provides a useful guide. Where the clinical circumstances of cases appear to be particularly relevant to matters falling within the inquiry's remit, within the clinical context of the ICR's processes, they would also be given priority, such as ones involving possible research under Term of Reference 2E, or claims of inadequate supervision or bullying of junior colleagues under Term of Reference 2B, or falling within the period of Mr. Eljamel's clinical supervision under Term of Reference 8. In order to allay concerns in this regard, we can say that we would be amenable to hearing representations on behalf of the patient co-participant group for inclusion in the next batch of priority cases for the ICR, which, as I say, the inquiry is already compiling. It may be that some of those suggested in the list appended to the patient group opening statement fall into this category, if not already in the top 50. Neurosurgical instruction. The expert neurosurgeons selected for instruction will be so selected by the ICR. Professor Wigmore, the chair of the ICR, is taking the lead in that process, ensuring the genuine independence of the experts, in particular from NHS Tayside. Though these are matters on which his representatives may address you further, sir, it is understood that Professor Wigmore has conducted further work in finalising the instruction of the experts, not least by liaising with the Society of British Neurological Surgeons. He will be finalising these arrangements and has asked the inquiry to continue to assist in providing information about what the inquiry will expect for the neurosurgeons who are instructed. The inquiry will be happy to do so. The applicant statement. Again, the inquiry understands that the next step will be that the applicants in the top 50 will be sent an applicant statement request with questions to answer, following a stepwise approach to the compilation of the materials needed for the review. It is important that applicant statements are completed in an efficient manner to allow the work of the ICR to progress and for the evidence which will be contained within them to be assimilated into the work of the ICR and the inquiry as soon as possible. As I have said, lack of progress in the work of the ICR was an issue ventilated at the preliminary hearing. A question was raised about it at First Minister's questions. Despite what I thought were clear assertions about the need for the remaining issues to be resolved, both at the hearing and in subsequent communication between you, sir, and the Cabinet Secretary, the inquiry has remained concerned about the lack of finalised plans in relation to a number of aspects of the work of the ICR, in particular connected to the completion of applicant statements, the next substantive step in its process. The inquiry has consistently issued plans to the ICR with regard to the timetabling of when work will need to be done to allow the inquiry to proceed with its own investigations. The ICR requires to produce its work in a way which accords with the inquiry's timetable, as per the provisions of the Memorandum of Understanding between the two processes. These plans have had to be revised and postponed. In order to try to draw up a clear plan for the way forward, the inquiry has recently met with Professor Wigmore in order better to understand what stage the ICR has reached in its preparations and its readiness to proceed with its work. As a result of those helpful discussions, for which the inquiry is grateful, it was apparent that there were a number of matters on which further clarity was required, which fall within the remit of the Scottish Ministers as the sponsors of the ICR process. Therefore, USR wrote to the Cabinet Secretary on the 20th of November, raising outstanding queries with him about the ICR. The inquiry intimated the note by Council to the ICR sponsor team last week, requesting that the Scottish Ministers provide an update on the matters raised either in a written submission in response to the note or at the opening statement hearing, and that they instruct appropriate representation at this hearing to allow matters to be addressed today. Clarity was sought on a number of substantially financial matters, which seem to be the logical impediments to getting the ICR underway. It is our understanding that those major impediments to the progress of the ICR project lie with the Scottish Government. It should be borne in mind that the ICR was the Scottish Government's invention. It funds it. It requires, it would appear, to put in place contracts and systems to enable it to work. Detailed procedural systems and operational timetables have been devised by the inquiry and ICR processes to allow the ICR to work as it was intended to do. The progress which has been made by the time the CTI note was drafted was welcome, but it was not sufficient. Whilst it is disappointing that the Scottish Government has once again not sought to engage with us today or instruct representation for today's hearing on behalf of the Cabinet Secretary in his capacity as ICR sponsor, I am pleased to say that a letter was received from him by you yesterday with an update on these important matters, to which I now turn. The inquiry understands there to be an agreement in principle that clients of Levy and McRae will be funded to receive legal support from their lawyers, and that similar support for other applicants otherwise represented will be funded at the same level. There appeared to us to be no clarity or finality surrounding the process by which legal services were to be engaged by the Scottish Government, both for the clients of Levy and McRae and otherwise, the anticipated timescale for this to be put in place, or even the ambit of what legal service would be covered, so as to allow the work of applicant statements being provided to the ICR to commence as soon as possible. The Cabinet Secretary has now confirmed that the ambit of the legal work for Levy and McRae clients and others will be support to draft the applicant statement, advice on any legal issues arising, and on the final neurosurgical report. It is clarified that while no legal contract is in place with Levy and McRae, they have been told that they are covered to respond to live queries. We assume that this cover must also cover any other solicitors instructed to whom applicants will be directed via the Law Society. We understand, therefore, that this legal support aspect of the plan is thus in place. The inquiry understands that some of the support services will be offered by the Patient Advice and Support Service Scotland, also known as PASS, and a separate psychological support service will also be offered via the ICR. There remained to us no clarity around what support services would be offered and how patients would engage with them. It has been clarified by the Cabinet Secretary that the PASS service will be provided by an amendment to an existing contract with the Scottish Government, that the PASS service are experienced in providing such support, and that they will receive training, and part of their agreement will be that statements will need to be in the words of the applicant. As far as we are concerned, the PASS service is available from now. It was clarified that the psychological support service will in fact be provided by funding by NHS Tayside. This position is also set out at paragraph 26 of NHS Tayside's written opening statement and paragraph 8 of their written submission. Reference to this is made, as I say, in that opening statement. We understand that this is now ready to proceed, though those in attendance today may benefit from some reassurance that this is an independent service. The Cabinet Secretary has assured you, sir, that it is. The inquiry understood that there also remained outstanding arrangements within the gift of the Scottish Government relating to the involvement of the consultant neurosurgeons in the ICR process. The details of these arrangements and the timescales for them to be completed remained unclear, but you have now been assured by the Cabinet Secretary, sir, that all such matters have been resolved. There is no further time for delay. Even with the inquiry's revised timetable, the work of the ICR must be allowed to get underway immediately. The evidential requirements of the inquiry demand that this happens now. Those who have waited years for the process to commence cannot be expected to wait any longer. It is our understanding that there are now no impediments to the work of the ICR getting underway, other than one minor remaining matter in the data protection impact assessment, which I anticipate can be ironed out this week. There appears to the inquiry to be no logical reason why the ICR cannot issue applicant statement requests to the top 50 patients next week. As per previously intimated timetables, this should allow the applicant statements to be completed by early in the new year, perhaps allowing some, based on a 4-week period to complete them, which Professor Wigmore, we understand, intends to use, inclusive of the opportunity for the inquiry to input into their content, to run further. That should enable the expert reports to be completed with inquiry input during February. If the 50 reports are completed by early March, that leaves 6 months to our Section 2 hearings. This will enable the work of the inquiry, which needs to follow, to be done to have things in place for those hearings. That work will involve Rule 8 requests being prepared and further inquiry statements being taken, as well as preparations for those hearings to be done. It will also take some account of those who will have an interest in the Section 1 hearings, which will need to be done in the period from January through February and March to the hearings in April, by which time the patient applicant statements will be complete for the top 50 cases at least. Those in the next priority list can then follow and also be taken into account as far as possible. If there are any issues with any of that, on behalf of any party represented at this hearing, I would urge those present to raise it here. Otherwise, that will remain the inquiry's expectation. As I have said to you, sir, the inquiry will give consideration to holding another hearing, possibly at the time of the February slot which we had, to ventilate any issues arising from that hard-fought plan. The instruction of the inquiry's expert witnesses. As set out previously, the inquiry will itself also instruct qualified experts in particular fields of expertise as experts to the inquiry. They will assist the inquiry either individually or as part of a group of such persons by way of the provision of written reports and opinions and, where appropriate, the giving of oral evidence at a public hearing. Such experts will have the appropriate expertise and experience for the particular instruction. They will be independent and objective and subject to an overriding duty to assist the inquiry on matters within their expertise. The appointment of experts to the inquiry, and whether they are assigned to a group of experts considering particular issues, are matters exclusively for the inquiry, although it will consider suggestions from core participants as to who should be appointed. Core participants will be informed of who has been instructed at an appropriate juncture in the process, as queried by NHS Tayside at paragraph 10 of their written submission. They will, of course, also have the expert reports to consider in the proposal of questions for the experts at inquiry evidential hearings, in particular in Section 1, though possibly beyond. NHS Tayside raised a similar issue relating to the disclosure of the identity of the ICR's experts. This is a matter which has not yet been agreed with the ICR, but the identities of the ICR experts will become known soon enough when the neurosurgical reports start to be completed and disclosed to core participants. There is a standing request with the ICR by the inquiry to provide CVs for their neurosurgical experts, which the inquiry would intend to peruse and disclose. The inquiry has provisionally identified a number of specialist areas in relation to which expert witnesses are likely to be giving evidence in Section 1. These areas will include neurosurgery. In order to supplement the significant body of expert neurosurgical evidence which the inquiry will have available to it from the ICR, the inquiry intends to seek expert evidence on matters including background to types of surgery performed by Mr. Eljamel, the responsibilities of consultant neurosurgeons, issues raised about problems with surgery or care, terms of reference 4 and 5, management of surgical lists, workload under term of reference 2, and the training of junior staff. Medical ethics. An expert or experts will be instructed to address the peculiarities of surgery and neurosurgery, consent issues, duties of candour, the pressures of private practice, obligations relating to research and other roles, training of junior staff and associated obligations, clinical supervision and suspension, duties when things go wrong, and obligations with regard to keeping notes and records. And finally, health administration and management, including the responsibility of health boards or other health bodies with regard to appointments and induction and training, management of workloads, clinical governance, the separation between professional and corporate clinical governance, private hospital coordination, requirements relating to complaints and feedback systems, investigative responsibilities of health bodies, duties of reporting to other health bodies, and document management systems and associated obligations. Draft letters of instructions for these experts, containing the questions and issues that the expert witnesses will be asked to address, will be disclosed to the core participants before the expert reports are instructed. Core participants will therefore be provided with an opportunity to provide observations on the scope of the matters which the experts are being asked to address. Core participants were also invited, in paragraph 13H of the guidance note sent to them for this hearing on the 29th of October, to make any proposals in their opening statements relating to the identity of expert witnesses or matters which core participants thought should be put to experts, including the proposed Section 1 experts. The inquiry team looks forward to considering any such suggestions in the aftermath of this hearing. Letters have been drafted to go to these potential experts or bodies to assist with the identification of the Section 1 experts. Council have started the process of drafting the Section 1 experts' letter of instruction, which will, as I say, be disseminated for their comment to core participants during December. Consultation and the inquiry's trauma-informed approach. Given that the inquiry was in a transitional phase at the time of the preliminary hearing as regards how it communicated with those with an interest in its work, the inquiry invited contributions from core participants at or in connection with the preliminary hearing as to their views on how they would wish the inquiry to communicate with them about the multiple matters on which they may come into contact with its work. This was and is part of the inquiry's ongoing commitment to listening to those with an interest in its work as to how they wish it to operate. The inquiry had little response in this regard, though remains committed to trying to get communication right. In order to seek to improve the ways that the inquiry engages with those with an interest in its work, including its core participants, the inquiry has launched an online public consultation on its trauma-informed policy, which it intends to implement in its work. The consultation paper contains an outline of the approach which the inquiry intends to take in this regard. The inquiry's trauma-informed policy will play an important part in its engagement strategy, given the number of key stakeholders in our work who have experienced trauma as a result of their experiences. The policy will be built around the trauma-informed principles of safety, trustworthiness, choice, collaboration and empowerment, and will seek to create a bespoke approach for a trauma-informed public inquiry based on the principles to which the inquiry has already committed itself and the reasonable requirements of those who have suffered trauma who are engaged in our work. This will certainly include former patients of Mr. Eljamel and may include others who will be invited to help shape the way that the policy will operate in practice. The results of this exercise will be fed into the inquiry's wider engagement strategy, which will set out the means by which the inquiry intends to engage with those with an interest in and a role to play in the inquiry's important work. This will be launched in due course as the inquiry moves into its evidential phase, as a means of seeking to promote the inquiry's principles of collaboration, listening and clarity. In the guidance sent out to core participants relating to this opening statement hearing at paragraph 13K, input on the inquiry's trauma-informed policy was invited in core participants' opening statements. Any contribution via this route is gratefully received and will be considered, along with the contributions to the public consultation itself. The inquiry is committed to finding effective ways to communicate and to its trauma-informed approach, not only in principle, but also in the ways it actually works on a day-to-day basis. The public consultation, led by the Deputy Secretary of the Inquiry, is designed to offer collaboration and empowerment to enable this commitment to be fulfilled to the best of our ability. Connected to our trauma-informed policy, the inquiry has now arranged for a tender process to be commenced, inviting bodies to run the inquiry's support service for those who engage with our work. That service will ultimately involve support being available to those who are participating in the work of the inquiry from trained counsellors. The tender process stipulates that those who wish to bid for the work must be independent of NHS Tayside, given the importance of the independence of that service to those who may wish to use it, having trust and confidence in the support that it will provide. As was the case in connection with the inquiry's public consultation events and the preliminary hearing, support services are available at this hearing today, provided by the SPARC, a Scottish-based charity which provides counselling and mental health support for individuals, couples, families, children and young people, and which has provided such services for 59 years. Many thanks indeed, sir, for the opportunity to provide this update, which I hope those with an interest in our work have found informative, and which I hope will lead to further progress and productivity in the inquiry's work. The hearing, as I have said, is predominantly about the contribution of core participants to various important aspects of our work, to which we will now turn.
Thank you very much indeed, Mr. Dawson. Now, Ms. Cherry, I'm going to turn to you next. I'm conscious that we're now at 12 o'clock. If your submission encroaches into lunchtime, I'll just rely on you to find an appropriate place that's convenient to stop. Thank you.
Well, thank you, sir, and good morning to everyone who's gathered here today. My name is Joanna Cherry, and I appear together with my learned junior, Ewan Scott, for the group of core participants, including former patients of Mr. Eljamel and their personal representatives. We're very grateful for the opportunity to make this opening statement to the inquiry, and we're also very grateful for the update we've had from Counsel to the inquiry this morning. The group which we represent comprises former patients and personal representatives of former patients who received treatment from Mr. Eljamel prior to his suspension from NHS Tayside in 2013. At present, the number of core participants, as we have heard, within that group is 159. The number has continued to grow as the true nature and extent of Mr. Eljamel's practice becomes more widely known. That group is represented by Levy and McRae, but it should be acknowledged from the outset that there are many other former patients or patient representatives who do not form part of the group, but who nevertheless have a keen interest in this inquiry's work. I speak only for those who are part of the group represented by Levy and McRae. That group appreciates, sir, that the focus of this public inquiry is on the systemic failures that led to Mr. Eljamel being in post for so long. The systemic failures that led to him being in post, notwithstanding his shocking record, his appalling behaviour which sometimes verged on the malicious, and numerous complaints about him and widespread knowledge about his record and behaviour. This inquiry has to find out why, notwithstanding all those things, he was able to continue treating patients for years. However, in order to understand the systemic failures, it is necessary first to appreciate the extent of the experiences that patients and their loved ones have endured and continue to endure. We welcome the recognition that this inquiry is to be patient-centred and trauma-informed, but we stress that this will necessitate a full understanding of the experience endured by patients and their loved ones. The voice of the patients and their loved ones must be heard. And I'd like to preface what I have to say this morning, sir, with just a small flavour of the human cost of Mr. Eljamel's actions and his inactions, drawing on what some of the individuals within the group have been able to tell me as we have consulted in recent months. Some patients in this group, sir, have undergone multiple surgeries at the hands of Mr. Eljamel. One patient describes how on the morning of her third surgery at Mr. Eljamel's hands, she was so scared that she vomited. She told a nurse that she had changed her mind and wanted to go home, but the next thing she remembers is waking up having had the surgery. The long-term implications of that spinal surgery, which was botched, have been so severe that she's lost her marriage as well as her job and her home. She's been through some very dark times and has come very close to taking her own life. The mess that Mr. Eljamel left her spine in is such that it is inoperable, and she suffers constant falls and broken limbs. Another patient was told by Mr. Eljamel that she was the perfect candidate for an experimental procedure involving the use of glue instead of sutures. He did not warn her of the risks of this procedure, including the increased risk of contracting meningitis. He did not tell her that she was part of a study, just that he had invented the glue that was being used. She went on to suffer appalling complications, including the contraction of meningitis, and had to have multiple further surgeries. She has lost the opportunity to have children and to run her small business, which she loved. Another patient was told by Mr. Eljamel that she was the first person in Europe to be treated using a new glue. The outcome of her surgery was so bad that she lost her job, but the most upsetting thing for her was that for a significant period of time, she was unable to pick up her baby or her toddler when they were very small and young at a time they most needed their mum. Years later, her general practitioner wishes to send her back to Ninewells for further treatment, but she is afraid to go. And she told us that NHS Fife have said she could go to a hospital in Edinburgh with her general practitioner's support, but sadly that support has not been forthcoming. Another patient had a titanium plate inserted into her spine by Mr. Eljamel, despite it being clear from her medical records and what she had told him that she had a metal allergy. She has not worked since the operation in 2013. Mr. Eljamel told another patient who was the victim of spinal surgery that had gone badly wrong, meaning that she lost her bladder function for a significant period of time. He told her that it was her fault because she had chipped a bone in her back. Of course, it's not just spinal surgery that Mr. Eljamel carried out, there was also brain surgery. We have another patient in our group who underwent 3 operations on their brain within the space of 2 weeks and was left with epilepsy and blindness in the right side of both eyes. This gentleman was left unable to read and write and had to take early retirement. Another patient was left paralysed from the neck down. One patient describes appalling histrionics by Mr. Eljamel when the results of the surgery that had gone wrong came to light. And this patient has told us that he was told by a nurse that Mr. Eljamel had actually come to physical blows with another surgeon who had challenged him about the severity of this patient's outcome. Many patients, sir, have found that other clinicians refuse to operate on them because they were previously patients of Mr. Eljamel and because of the condition in which they have been left by Mr. Eljamel. One patient poignantly recalls the dying words of her mother, who supported her through years of trauma at Mr. Eljamel's hand. And that lady said it was a shame that she would not be alive to see Mr. Eljamel brought to justice. Sir, that is just a flavour of the evidence that we have heard from those we represent. Now, when a patient consents to treatment from a surgeon, particularly a neurosurgeon, they are literally putting their life in that surgeon's hands. It's really quite hard to imagine a surrender which is more complete and which renders a patient more vulnerable. And therefore, the bond of trust in that situation is of the utmost importance. And this inquiry is about how the betrayal of that trust was allowed to happen repeatedly and why it was allowed to happen for so long. It is also about the way patients and their loved ones have been treated simply for daring to seek answers and redress. You, sir, will be familiar, as many will in this room, with the report about the Hillsborough family's long search for truth and justice. That report was entitled "The Patronising Disposition of Unaccountable Power." That phrase was chosen to describe the systemic attitude of the authorities towards the Hillsborough families and to highlight how those with power displayed a dismissive and condescending attitude while avoiding responsibility for failures that prolonged the suffering of those affected by the disaster. That phrase, in my respectful submission, the patronising disposition of unaccountable power, is also apt to describe the experience of the group and their loved ones, not just at the hands of Mr. Eljamel, but also at the hands of NHS Tayside, the Scottish Government and other authorities whose actions will be examined by this inquiry. The group and their loved ones need recognition, accountability and justice for years of suffering and years of deceit. They are seeking answers not just for Mr. Eljamel's actions, but also for the subsequent cover-ups and the impact that these cover-ups have had upon them. As is well known, members within the group have campaigned tirelessly for the establishment of this public inquiry. Campaigners first called for a public inquiry in 2014 following Mr. Eljamel's suspension from NHS Tayside, which is of course now more than a decade ago. The Scottish Government repeatedly resisted calls for a full public inquiry, insisting that internal NHS reviews were sufficient. Following a series of unsatisfactory internal reviews and in the face of continued procrastination, delays and obstructions by NHS Tayside and the Scottish Government, the campaign for a public inquiry gathered momentum, with patients staging a series of public protests throughout 2022 and 2023. Whilst every patient's treatment and circumstances is unique, as will become clear, the evidence before the inquiry will reveal a common experience, both in terms of the treatment received from Mr. Eljamel, but also in terms of the actions and inaction of NHS Tayside in response to reasonable concerns. A common experience is that the systems in place designed to protect and promote a patient's well-being were wholly inadequate, and members of the group have thus been left with little or no trust in the NHS. One hopes that this inquiry might be able to restore that trust, if not for all the patients in the group, but perhaps more for the general public. Now, in my statement this morning, I'm going to address 5 chapters. First of all, the purpose of this public inquiry and its terms of reference. Secondly, the group's experiences at the hands of Mr. Eljamel and the NHS. Thirdly, the group's experiences trying to get justice. Fourthly, learning from the process of setting up the public inquiry and the independent clinical review. And fifth and finally, expectations and the future. So I turn to the first chapter of my oral statement, the purpose of this public inquiry and its terms of reference, and for the assistance of those who've had the benefit of seeing the written statement, which I and my learned junior lodged on behalf of the patient group. I'll be largely following the layout in that written statement. Turning first to the purpose of this inquiry, as I've said, its purpose is to establish facts, ensure accountability and make recommendations for the future. And that purpose could not be more important, considering that the concerns raised involve the National Health Service and how healthcare is delivered to the people of Scotland. The Cabinet Secretary for NHS Recovery, Health and Social Care recognised this when he announced the inquiry. And he said, and I quote, "Few things are more important than the safety of patients in our health service. Perhaps equally critical is the trust that we, as individuals and communities, can have in our healthcare. Patients must also trust that any concerns that are raised about their care and treatment will be investigated and that the necessary actions will be taken. They must be able to trust that their concerns will be investigated and scrutinised and will be subject to robust governance and due diligence at the time, not several years later. When trust is broken and weakness in governance is identified, it is imperative that we do all that we can to investigate why that has happened and to prevent others having the same kinds of distressing and traumatic experiences." And I end there the quote from the Cabinet Secretary. So to summarise, sir, put shortly, this inquiry is absolutely necessary to restore trust in our NHS and the various other institutions that are designed to protect patients. Too many people have suffered both physically and mentally due to the actions of Mr. Eljamel. Many have been left with life-changing injuries. And as I said, some have found themselves to be in a situation where basically nothing can be done for them, or clinicians are reluctant to provide further treatment due to concerns over what Mr. Eljamel has done, so the suffering continues. Too many patients also received a wholly inadequate response to their concerns when raised with NHS Tayside. They believe the NHS Tayside have evaded both moral and legal accountability. And despite placing their trust and well-being with the NHS, patients have experienced at the hands of NHS Tayside poor communication, a lack of candour, evasiveness, and at times dishonesty. For the group, their concerns are not limited solely to Mr. Eljamel and NHS Tayside. They extend to other institutions involved in or responsible for their care. Because despite concerns existing over the practice of Mr. Eljamel, it seems to the group that these organisations sat silent. Patients were still continuously referred to Mr. Eljamel for treatment. He was permitted to train and teach future clinicians that continue to work in the NHS today. And the importance of investigating that lasting impact that Mr. Eljamel has had on the NHS cannot be overstated. Accordingly, this inquiry must ensure that organisations designed to provide oversight are scrutinised to ensure the accountability of individuals within these organisations for allowing Mr. Eljamel to continue to practice in the manner that he did for as long as he did. And it's only with proper scrutiny that the public can be satisfied that these organisations are fit for purpose, notwithstanding their failures in relation to Mr. Eljamel. It is apparent, sir, from our discussions with members of the patient group, that Mr. Eljamel was not simply a rogue surgeon acting without the knowledge and tacit approval of colleagues. Other healthcare workers were aware. Some appear to have challenged the conduct but elected to take it no further. Others appear to have simply permitted the conduct to continue. The systems that were in place within NHS Tayside require very close scrutiny. The details of a number of individual clinicians and employees of NHS Tayside from whom we believe evidence should be sought have been provided to the inquiry this morning. It has taken us some time to compile that list because it's quite lengthy, but we feel it's also incumbent upon NHS Tayside to identify such witnesses, and we hope pressure will be brought upon them to do so. The group expects the Chair and Counsel to the inquiry to scrutinise clinicians and management employed by NHS Tayside, as well as NHS Tayside itself, without fear or favour, and we have confidence that they will strive to do so. There is an expectation that the relevant facts are fully and fairly investigated so that recommendations can be made to avoid similar issues arising in the future. But first and foremost, what the group expect is accountability. Accountability from the organisations that failed to put the patient's interests first. Accountability from individuals who turned a blind eye. Accountability from those individuals who permitted Mr. Eljamel to continue practising when concerns were evident. And accountability for both the individuals and organisations that are responsible for what has happened to the patients and the lasting effects. The group expect truth and justice, and that, in my submission, is the purpose of this inquiry. Now, turning to the terms of reference, following a public consultation exercise, those have been fixed, and the group were very grateful for the opportunity to provide comment on the terms of reference and the list of issues. And we were particularly grateful that so many of our suggestions for the list of issues were taken on board. Now, you, sir, are already familiar with the concerns of the group about what has been excluded from the terms of reference. It is, of course, appreciated that the terms of reference have been determined by the relevant Scottish Government Minister. However, there remains a very strong feeling within the group that A, the inquiry ought to fully examine the role of the private healthcare sector, and B, that it is very unfortunate that the inquiry does not have jurisdiction to determine any fact or make any recommendation which is not wholly or primarily concerned with a Scottish matter. And these are not criticisms of the inquiry, they are criticisms of the way in which the inquiry has been set up. So the group hopes that when the inquiry comes to investigate the creation of the inquiry itself under term of reference 12, both the decision to exclude a fuller examination of the role of the private healthcare sector and the decision not to hold a joint inquiry with the UK government will be interrogated. Because, of course, a joint inquiry would have enabled full investigation of organisations such as the General Medical Council and the Health and Safety Executive, which are the responsibility of the UK government. The group cannot understand why this wasn't done, and they wish to see Scottish Government ministers held to account for their choices. We note that counsel to the inquiry very helpfully clarified at the preliminary hearing that evidence will be sought from the GMC and the HSE to help inform the discharge of the terms of reference, and that in particular the GMC will be called upon to produce evidence relating to the role of NHS Tayside under term of reference 11 in the voluntary removal by Mr Eljamel of his name from the medical register. And we also note that while the inquiry cannot make findings about the role of the Health and Safety Executive, it can make findings about the role of Health Improvement Scotland in relation to their functions of inspection and regulation of clinical services to ensure they meet safety and quality standards. We understand, sir, that Health Improvement Scotland have a memorandum of understanding with the Health and Safety Executive, and we should like to hear evidence about this and understand how it works in practice. Turning to the issue of private health care, we note, of course, that the inquiry requires under term of reference 2A to investigate whether Mr Eljamel's private practice commitments contributed to adverse outcomes for his NHS patients. Under term of reference 3, the inquiry will require to look at whether there are clues from what was going on in his private practice that should perhaps have been detected so as to protect NHS patients from harm. We believe it will also be necessary to consider issues relating to the granting of practising privileges to Mr Eljamel at Fernbrae Hospital under term of reference 2A. The group contains patients, sir, who have reason to believe that they were encouraged by Mr Eljamel to go private, in the colloquial term, for unnecessary surgeries, patients who were made to wait for private care when their condition was so grave they should have been fast-tracked on the NHS lists, and patients who believe they underwent unnecessary procedures simply because Mr Eljamel knew that they had private health insurance. We note, as has been emphasised this morning, that the experience of private patients will be captured by the independent clinical review and available to the inquiry. And these matters are also, of course, within the purview of Health Improvement Scotland, whose remit includes enabling the people of Scotland to experience the best quality of health and social care in both public and private sectors. While it is acknowledged, sir, that the independent clinical review is going to permit examination of Mr Eljamel's clinical work within the private sector, we fear that the absence of such examination by the inquiry could respectfully result in an incomplete and skewed analysis of the full extent of Mr Eljamel's actions and how he was able to continue for so long. This could, in due course, limit the effectiveness of any recommendations made, and this is particularly so given the extent that the private healthcare sector interacts with the NHS within Scotland. It is hoped, sir, that you might consider whether you should make representations to the relevant minister to widen the scope of the terms of reference in relation to the private healthcare sector in due course. I turn now to an important issue regarding Mr Eljamel's supervision of NHS colleagues within the NHS, which is covered by term of reference 2B. We believe it's very important to consider what impact, if any, his role at the University of Dundee had on trainee or student doctors challenging his behaviour or raising clinical concerns within NHS Tayside. Separately, the partner of one patient within the group, overheard junior doctors discussing the potential need for them to repeat their rotations undertaken under Mr. Eljamel's supervision when he was finally suspended. I respectfully suggest the inquiry should investigate whether this occurred and what steps were taken to ensure that trainees under his supervision were prevented from replicating his suboptimal practices in their own professional practice. Also in relation to term of reference 2D and E, one member of the group with contemporaneous professional experience of the University of Dundee has told us of the awe in which Mr. Eljamel was held at the university, the impression that he was untouchable, and concerns about his role in helping the university get research funding, and his relationship with organisations promoting research on new or experimental techniques. As we have heard this morning from Counsel to the Inquiry, the University of Dundee is of course a core participant in this inquiry. We note that their written opening statement refers to the severe financial constraints under which the university currently finds itself. It's not clear, sir, but from the brevity of that opening statement, we suspect those financial constraints are being raised in order to indicate that the university may be constrained in its participation in this inquiry. And I'd wish to associate myself with what Counsel to the Inquiry said earlier this morning, that the extent of their representation is of course a matter for the university, but it goes without saying that financial constraints will be no answer to their compliance with orders made by the inquiry for the recovery of evidence. Now, I'm glad we're all on the same page about that. Lastly, under the first chapter of my submission, I want to mention briefly the position of NHS Fife. You, sir, will have seen from our written opening statement that we would wish the inquiry to consider, under term of reference 6, why clinicians and GPs, including those within NHS Fife, continue to refer patients to Mr. Eljamel, notwithstanding concerns raised, or concerns which should have been self-evident from the results of his treatment of his patients. I turn now to Chapter 2, the group and their experiences at the hands of Mr. Eljamel and the NHS. I've said a little about this already in my introduction, but I want to say a little more about it now. The group contains patients or relatives of patients who were treated by Mr. Eljamel between 1995 and 2013, and there is rightly a lot of focus on the period in 2013, but the group does contain people who were operated on long before that and right back at the beginning of the relevant period. Many of them have suffered life-changing injuries, as I've said, for example, loss of sight and paralysis. But they've also been left with injuries which are not just physical, but also psychological, mental and emotional. Some have suffered suicidal ideation. Some have lost their jobs, their ability to access work and education, their homes, their marriages and their families. The impact on their families and their loved ones has also been profound. And these are not just historic experiences. Members of the group live daily with life-limiting injuries at the hands of Mr. Eljamel. Some of the group are representatives of patients who have succumbed to their injuries or died without seeing justice. And at least one member of the group is the relative of a patient who recently died from another condition, but the Procurator Fiscal requested a post-mortem because the deceased had been a patient of Mr. Eljamel, with all the consequent additional distress that occasioned. No criticism of the Procurator Fiscal is intended, but it's just another example of the long-term effects of Mr. Eljamel's actions. The group have been impacted, as I said, not just by what Mr. Eljamel did to patients in the operating theatre, but also how he behaved towards them when they sought follow-up. The words most frequently used to describe him are evasive, arrogant, and chauvinist. and at least one member of the group describes vividly their dismay at realising that Mr. Eljamel had absolutely no idea what to do in their case. The impact on the group extends beyond the physical and psychological consequences of their treatments at the hands of Mr. Eljamel to distress about the way they were treated by other NHS staff. Many patients describe being referred to as season ticket holders or frequent flyers because of their need for continuing treatment. And some describe feeling gaslit by NHS staff and made to feel confused, anxious and unable to trust their own instincts. This behaviour has exasperated the suffering of members of the group at Mr. Eljamel's hands. I was pleased to hear the acceptance this morning that the remit of the inquiry must extend beyond Mr. Eljamel's practice at Ninewells Hospital into other NHS hospitals where he might have practiced or referred patients for procedures connected with his treatment, and that includes Dundee Royal Infirmary and possibly also Perth Royal Infirmary. Now, whilst it is fully understood that the inquiry's terms of reference largely focus on systemic issues, the group is grateful that an opportunity is going to be afforded to some of them to tell their story in Section 2 of this inquiry. It is, in my respectful submission, essential that this happens, because it's only by listening to members of the group and other patients affected that systemic issues can be properly identified and highlighted so as to fulfil the inquiry's terms of reference. To that end, the group are grateful to the inquiry for adopting a trauma-informed approach to the taking of their evidence, and we look forward to being consulted on what is proposed, as the Counsel to the Inquiry has outlined earlier today. I was also grateful to hear Counsel for the Inquiry give some clarity about the methodology that had been used to select priority cases for the independent clinical review and the triage system that had been followed, and the fact that members of the group which I represent and other patients should not assume, if they're not included within the initial list of priority cases, that their case is not being treated with equal importance. It's good to have that clarification. It's also good to hear that those instructing me will be consulted about further additions to the priority cases. There have been difficulties over the ICR. I don't intend to go into them in any great detail this morning, but it's important to realise that because of the delays on behalf of the Scottish Government mentioned by Counsel to the Inquiry earlier this morning, that those instructing me are still not formally instructed in relation to the independent clinical review because there's no final agreement in place. And that is through no fault of those instructing me. But we are very grateful to the inquiry team for the pressure that has been brought on the Scottish Government to try and get things moving. One practical point of concern, which I should mention in passing just now, is that I heard what my learned friend had to say about the plan for the next few weeks, and I very much hope that it's going to proceed with the expedition which my learned friend has striven so hard to get. I was just slightly concerned that those instructing me, and more importantly the patient group, might find themselves in the situation where the 4-week period that was referred to falls over the holiday period, and that might make things slightly difficult for people. But that's a procedural matter which I'm sure I can iron out behind the scenes with my learned friend. As I say, I'm grateful to him and you, sir, for all the work that has been put into getting the independent clinical review off the ground. I'm also grateful to Professor Wigmore for the benefit of the meetings that I have had. Some members of the group I represent remain cautious about the independent clinical review. They have, however, been encouraged to engage with the independent clinical review, with its importance being emphasised, and will now, of course, have the support of their solicitors to do so. My learned friend spoke about some of the themes that emerge from Mr. Eljamel's practice. I'd wish to say that every patient experience is unique, but from the information I have to date, I have been able to identify some common themes. These include the absence of informed consent, warnings about underlying conditions in medical records which were ignored, surgeries performed by junior colleagues without adequate supervision, the use of experimental techniques and medical devices which were new to the market, the lack of expertise to perform specific surgeries, surgical mistakes which could have been avoided, wrong site surgeries, ghost surgeries where the surgery for which the patient was consented was not actually carried out, the absence of basic oversight and investigation, the awareness of concerns that were not acted upon, bullying and intimidating behaviour, the absence of meaningful communication, the lack of transparency and the lack of candour. That is by no means meant to be an exhaustive list, but it's a pattern that I and my junior have been able to identify from the information we have. I want to turn now to Chapter 3 of my submission, which relates to the group's experiences as they attempted to get justice. The conduct of Mr. Eljamel and its impact on patients, as I've said, must be examined. But the wrongs inflicted upon members of the group did not end there. Each and every member of their group put their trust and faith in Mr. Eljamel, but also our National Health Service when they were at their most vulnerable. And they trusted all the healthcare employees involved in their care, and they trusted that they would act with expertise and honesty and with their best interests at the forefront of their minds. That trust was broken not just by allowing Mr. Eljamel to continue practising, but in how NHS Tayside has sought to address the concerns that have since arisen. And the group want answers to why that has happened in order to ensure it doesn't happen again. Now, we understand that individuals within the group, as well as at least one whistleblower, raised complaints or concerns about Mr. Eljamel's practices prior to 2012, and we've given the name of that whistleblower in our list of witnesses. The Royal College of Surgeons England report dated 6 December 2013 records that there were 4 complaints about Mr. Eljamel in 2012 and 3 in 2011. And in the undated report by Mr. Donald Campbell on the Gillis report, it is recorded, and I quote, "This surgeon had 3.5 times as many complaints in the space of 2 years than the average number of complaints made in a whole professional lifetime for the average surgeon. This is an obvious pattern and should have raised queries in 2013, if not before." And that's the end of the quote. I'm sure more information about all of this will be captured by the independent clinical review patient statements. But it's important to emphasise that the group's experiences are not just historic. Members within the group continue to experience difficulties in how NHS Tayside address their complaints and their continued care. There have been data protection issues. We have heard examples of NHS Tayside refusing or claiming to be unable to provide patients with their medical records. Of particular concern is where further treatment and/or investigations have been refused due to the historic involvement of Mr. Eljamel. Patients within the group feel that they have in effect been blacklisted for daring to raise concerns. Accordingly, it's vital that when listening to the former patients, the inquiry consider to what extent institutions have contributed and are indeed still contributing to the wrongs originally inflicted by Mr. Eljamel. In this connection, sir, I wish to raise a very serious matter which has come to light in the last few days. Members of the group and the legal team were appalled to read in NHS Tayside's written opening statement that the board has recently discovered that around 40 hard copy theatre logbooks, which would have contained information relating to Mr. Eljamel's surgeries in the period 95 to 2013, were destroyed by NHS Tayside employees this summer on the 24th of July 2025. It beggars belief that this should have occurred, notwithstanding everything that has gone before. Patients and their representatives have repeatedly raised concerns that their medical records may have been tampered with or be incomplete. And in these circumstances, it should have been obvious that these logbooks might have provided vital evidence for this inquiry to fill gaps in patient records. You, sir, of course, issued formal do not destroy notices on the 11th of October 2024. We fail to see how this wanton destruction of vital evidence could have happened if NHS Tayside had put proper systems in place to comply with that do not destroy notice. And that's particularly so given the terms of the protocol on the production, handling and retention of documents, which you, sir, issued on the 8th of May. It seems to us that the only explanation for what has occurred must be gross negligence or indeed possible malice. Now, of course, offences may have been committed under Section 35 of the Inquiries Act 2005, but at the preliminary hearing, sir, you said that you wouldn't hesitate to use your statutory powers to call for or to recover evidence, and in due course to compel the attendance of witnesses in order to exhaust the terms of reference. We would hope that, as I think was indicated by counsel to the inquiry this morning, that witnesses will be called upon to give evidence on oath about how these documents came to be destroyed. And in our view, such witnesses should include NHS Tayside's Chief Executive and Chief Operating Officer, together with the chain of command right down to those who destroyed the evidence. I heard that we might be having further preliminary hearings, and I would hope that perhaps the time that was originally set aside in February, some of it might be used to get to the bottom of why it was possible for this vital evidence to be destroyed. Now, turning to the examination of previous reviews and investigations, the group wished the inquiry to investigate concerns about a number of issues. One of those is the extent of the supervision afforded in 2013. Another is why the Royal College of Surgeons England were instructed only to investigate spinal surgery and not brain surgery. A third concern is why no thought was given to a potential conflict of interest when at least one known internal review of a complaint by NHS Tayside in 2015 was carried out by the same clinician who had been responsible for supervising Mr. Eljamel. Another concern is Mr. Eljamel's failure to attend routine multidisciplinary meetings and his alleged failure to carry a bleep. We also would wish the inquiry in this connection to look at the circumstances surrounding a complaint we believe to have been made by the Tayside Local Medical Committee regarding Mr. Eljamel, and we have provided witness names who might be able to assist the inquiry with that. I turn now to Chapter 4, learnings from the process of setting up the public inquiry and the independent clinical review. The members of the group are very glad, of course, that the Scottish Government eventually acceded to their request to establish the public inquiry to examine the issues with which we are concerned today. However, they do have some concerns over the manner in which these issues will be explored. And as I've stressed or tried to stress today, careful examination of the patient experience is necessary before we can properly identify systemic issues. And such identification is obviously necessary for the inquiry to fulfil its stated remit. The Scottish Government have, however, elected to largely outsource examination of clinical issues to the independent clinical review, with difficulties about limited support. being afforded to that review and also to the group to interact with it. I'm hoping that we are getting over some of those issues now, and I was comforted by some of what Counsel to the Inquiry had to say earlier this morning. However, when the independent clinical review was originally announced, many patients thought that the government's emphasis on their needs meant that it would provide an avenue to explore future treatment. That's clearly not the case, and they have been left disappointed and in some cases angry after learning that that is not now the purpose of the independent clinical review. It was, of course, designed to be an adjunct to the inquiry as matters evolved. It doesn't have the same powers that are available to the inquiry. For example, it cannot compel organisations to provide relevant documentation. Members of the group have in the past experienced significant difficulty in obtaining their medical records. Some have obtained medical records which are partial, and some have been told that medical records have been destroyed. One member of the group has told us of how Mr. Eljamel kept her child's medical records in a locked drawer in his room. So I think it's very fair to say that members of the group have legitimate concerns that medical records are not as they should be, that they may be incomplete, they may have been falsified, and they may have been deliberately destroyed. Now, of course, as we know, the independent clinical review is reliant on the inquiry for the purposes of recovering those medical records. This has meant something of a delay, I think, but we were comforted this morning by what Counsel to the Inquiry had to say about that. But the extent of issues associated with the medical records and the absence of proper accountability of organisations to the independent clinical review in that regard remain a concern to the group. As noted by Counsel to the Inquiry at the preliminary hearing back in September, progress with the ICR's work is vital. And we are grateful to Professor Wigmore for the time he has given to us as legal representatives of the group to explain what was happening. And we are pleased to hear about the progress that we've heard about this morning. However, it goes without saying that the patient group are disappointed about the cancellation of February's hearings and the postponement of Section 1 to April. This means, of course, that the voices of patients and their representatives will not be heard by this inquiry in Section 2 now until the autumn. And it's incumbent upon me to say that the group would like to have assurances that there will be no further delays and to know exactly when the Section 2 hearings will take place. Now, I know that we're going to have 4 weeks in September, and I'm very grateful to Counsel to the inquiry for telling us that this morning, but I suspect there will probably need to be more than one diet of hearings to deal with the Section 2 hearings. Now, Chair, I'm coming to part 5 and my conclusion. I can do one of two things. I can finish, which I anticipate doing in about 15 minutes, or I'm in your hands, sir, as to whether or not you might wish to take a break now. But I'm very happy to finish if that's what you would prefer.
I think we'll just press on unless there's any pressing concern.
Excellent, thank you. Right. So I'm coming now to Chapter 5. And Chapter 5 of my submission this morning relates to expectations and the future. The group accept that a number of hearings will be required to properly explore the issues with which this inquiry is concerned, and that it will take time. Their trust in the NHS has been broken, and it is anticipated that the trust placed in the NHS by the wider public will be tested once the conduct of Mr. Eljamel, together with the systems and individuals that enabled that conduct, comes under the microscope. Some members of the group accept that they may not be alive to see the inquiry fulfil its purpose. But to properly identify the systemic issues and to leave a legacy of change, it's imperative that the perspective of the patient is taken into account. Public confidence in the NHS requires it to be rebuilt. Public confidence in other institutions which may have failed to address Mr. Eljamel's behaviour or indeed sought to minimise it and needs to be restored. But even then, members of the group will continue to be distrustful of the NHS. They have faced obstacles in having their concerns listened to. As I said, some feel ignored, others feel blacklisted. And despite assertions to the contrary, NHS Tayside continues to adopt an overly defensive stance to both complaints and legal claims made by members of the group. And the perception of members of the group is that NHS Tayside is more concerned with protecting its image than it is concerned with patient safety and well-being. And there I'm talking about the institution rather than its employees. So whilst it is fully appreciated that this public inquiry's function is not to determine any person or body's civil or criminal liability, we note that counsel to the inquiry said at the preliminary hearing that the inquiry can undertake investigations and make findings and recommendations from which criminality might be inferred. Equally, it has the power to undertake investigations and to make findings and recommendations from which civil liability might be inferred. There's an ongoing police investigation into Mr. Eljamel's actions. Some members of the group have been denied compensation by NHS Tayside, citing legal technicalities relating to the passage of time. The group would like to see NHS Tayside and the Scottish Government act to override these technicalities. They would like to see this done not on a case-by-case basis, as has been suggested by the Government to date, but across the board for all patients damaged by Mr. Eljamel, so that all may be compensated. We hope that it might be possible for recommendations to be made which will encourage this to happen. In particular, it is hoped that the inquiry will investigate whether failures on the part of any relevant organisation to inform people who were affected timelessly impacted on the opportunity of patients to seek redress or compensation and to make findings in this regard and consequent recommendations. Under term of reference 18, the inquiry we submit could make recommendations as to treatment, care and support for the group in the future, and it is submitted that these could be made by way of interim recommendations after the Section 2 hearings. Finally, it's a small point, but perhaps important. A member of the group has brought to our attention that Mr. Eljamel has written a textbook entitled Problem-Based Neurosurgery, which was published in 2011 and which is still available to purchase and may be in some university libraries. The group would like to see the inquiry consider recommendations about what should be done about this book. To conclude, sir, this inquiry has been a long time coming and very hard fought for. The group are fully intent on supporting the inquiry so that it may fulfil its remit. But the former patients of Mr. Eljamel must be at the heart of this inquiry. Without their efforts, it would not be happening, and they and their representatives require to be listened to for any lessons to be learned. Although the substantive part of the inquiry has not yet begun, the group are confident that the inquiry will strive to uncover the truth and to shine a light on what has for too long been shrouded in secrecy. They have every confidence that the Chair, Counsel to the Inquiry and his team will explore these issues without fear or favour. We remain grateful to the Chair and Counsel to the Inquiry and their team for the empathy and compassion shown to date. We remain committed to working further with the inquiry, knowing that those we represent will finally be afforded an opportunity to tell their story and to see justice and accountability. Thank you.
Thank you very much indeed. Now we will move after lunch to the next statement, which will be an oral opening statement given by Ms Doherty on behalf of NHS Tayside. But perhaps we will leave that, Ms Doherty, until 2 o'clock and we'll take lunch now. Thank you.